everywhere. There's no place to put the coffee. She put it between her knees and lifted the lid off.
Other athletes have done the same. I feel the need to protect my name, my identity.
Strong reason for why they brewed their coffee at the temperature they did.
Judges had to deal with this case is egregious, and so the cost to the taxpayers and the cost to pay the judge.
Woman who says she found a finger in her bowl of chili at a Wendy's in San Jose, California. We turn now.
That we had his pants ready for him, and that we hadn't in fact lost his pants. And with respect to the signage.
Number 8, take them to the cleaners. Like many other recent college graduates, 27-year-old Trina Thompson had struggled to land a job since getting her diploma in April 2009. But instead of blaming the recession for her unemployment woes, the New York City native filed a lawsuit against her alma mater, Monroe College in the Bronx, to recoup the $70,000 she'd spent on a bachelor's degree in information technology, saying the school's Office of Career Advancement had failed miserably at helping her advance her career.
To cover a certain segment of cases and their holdings was what my role was. Talk about seminal cases. The cases that I talked about were those that were in the static history, dilution of the law, and how it is that we have a static history that we all have. And then we talked about how we evolve over time. And then we challenge young people.
Thompson is also asking for $2,000 to make up for the stress of her fruitless 3-month job search. But it doesn't look as if the folks at Monroe College are going to pony up anytime soon. So much for teaching them a lesson. Number 7, McDonald's pays the price. In 1992, Stella Liebeck, then 79, was in the passenger seat of her parked car when she spilled a scalding 49-cent cup of McDonald's coffee on her lap, causing third-degree burns that required skin grafts and 2 years of treatment.
So that other people will not go through the same thing.
Everywhere. There's no place to put the coffee. She put it between her knees and lifted the lid off. Sweatsuit that she was wearing and pooled in the seat.
Unreasonably hot and therefore unreasonably dangerous. And those were the essential factors. It was dangerous and it was burning people. We argued that to the jury, that they were callous and indifferent.
It's statistically insignificant. And we're not going to change what we do.
After attempting to settle with McDonald's for $20,000, enough, she said, to cover her medical costs, Liebeck brought the case to court in 1994, when the fast food giant countered by offering a paltry $800. Although a jury awarded Liebeck $160,000 in compensatory damages and $2.7 million in punitive damages, McDonald's and Liebeck reached an undisclosed out-of-court settlement to preclude the possibility of appeals. Liebeck's lawsuit became a media sensation and, fairly or otherwise, transformed her into the poster child for frivolous lawsuits. Today, Liebeck is the namesake for the Stella Awards, which are distributed annually to the most laughable legal claims. Perhaps the most unfortunate part of the crazy clash is that Liebeck, who died in 2004 at the age of 91, didn't live to see the addition of iced coffee to McDonald's menu.
Sued McDonald's and collected.
Necessarily mean that the restaurant is doing something wrong. Strong reason for why they brewed their coffee at the temperature they did.
The severity of the burns, they would have realized it was not a laughing matter. See Judge Scott going like this with his pencil, and I thought, oh, I hope he's counting digits on the
49 words in the AP, and became as few as 48 words in various rendering.
It's like bullying. It feels like bullying.
I mean, it's not like the McDonald's person leaned over the car.
Number 6, mistaken identity. Plenty of people think professional athletes earn too much money, but former newspaper carrier Mark Guthrie probably isn't among them. While working for the Hartford Courant, Guthrie received payments intended for another Mark Guthrie employed by the Tribune Company, in this case a relief pitcher for the Chicago Cubs. The payroll mistake resulted in the poorer Guthrie getting a $301,000 boost to his bank account. When the company recouped $275,000 of that sum, Guthrie froze his account and informed the Tribune Company that the rest would be returned when they assured him that he would receive his own salary, and that the snafu wouldn't force him to contend with tax snags stemming from the overpayment. Instead, Tribune lawyers sued him for the rest of the money. Number 5, who wants to be Michael Jordan? Apparently not everyone wants to be like Mike. In 2006, Alan Heckard of Portland, Oregon sued Michael Jordan for $416 million on the grounds that his resemblance to the Hoops legend caused emotional pain and suffering, defamation, and permanent injury.
When someone takes advantage or misrepresents that, I think it's left up to me to protect that. And when you have your name, it is your DNA. And when someone takes it then I think it's about other athletes who've done the same. I feel the need to protect my name, my identity.
He sued Nike for the same amount, faulting them for making Jordan a celebrity. Heckert, who stands about 6 inches shorter than his heiress, said he could not attend religious services, ride public transportation, play sports in public parks, or eat at a restaurant without getting mistaken for the former Chicago Bulls guard. Maybe Heckert's shaved head, earring, and Air Jordan sneakers had something to do with that? I'm constantly being accused of looking like Michael, and it makes it very uncomfortable for me, Heckert said. Even when I go to the gym, I'm being accused of playing ball like him. Yes, it's easy to see how that would cause emotional pain and suffering. Heckert eventually dropped the suit. Number 4, Allen goes to court. The talk was tough, but definitely not cheap. After director Woody Allen filed a $10 million lawsuit against American Apparel Inc. for unlawful use of his image to sell merchandise, attorneys for the clothing company fired back by requesting information about Allen's family life, personal finances, and career. The company's motive? To construct the argument that Allen's image wasn't worth that much. After the various sex scandals that Woody Allen has been associated with, corporate America's desire to have Woody Allen endorse their product is not what he may believe it is, said corporate spokesman Stuart Slotnick, who added that Allen's ex-wife, actress Mia Farrow, and her adopted daughter Sunyi Previn, whom Allen married, could be subpoenaed to testify. On May 18, 2009, the day the trial was set to begin in a Manhattan courtroom, American Apparel settled the suit and agreed to pay the director $5 million. Number 3, finger licking good. In 2005, while eating chili at a Wendy's in San Jose, California, Ana Ayala claimed to bite into a 1.5-inch crunchy finger. In the first step toward a potentially lucrative lawsuit, Ayala filed a claim with the franchise, earning her tabloid notoriety and turning the fast food chain into a national punchline. Ayala's story started sounding fishy, however, when lab tests turned up no traces of saliva on the offending digit. A CSI type of investigation was not consistent with an object that had been cooked in chili at 170 degrees Fahrenheit for 3 hours and therefore must have been planted in the chili after the fact.
A woman who says she found a finger in her bowl of chili at a Wendy's in San Jose, California. We turn now.
I usually crack all my crackers and just put them in there, mix it all around, and started eating something that's kind of hard, crunchy, spit it out. At first I wasn't sure what it was. That's when we find that there's something that looks like a nail.
As it turns out, Ayala's husband, Jamie Plasencia, had bought the severed finger from a coworker who had recently lost it in an on-the-job accident for $100. The couple had offered the man, Brian Rossiter, $250,000 to keep the plan under wraps. In September 2005, Ayala and Plasencia pleaded guilty to conspiracy to file a false insurance claim and attempted grand theft with damages exceeding $2.5 million. Ayala was sentenced to 9 years in prison. Plasencia got 12. In a tearful courtroom appeal for leniency, Ayala called the scam a moment of poor judgment. The lesson here? If you're going to plant a finger in your food to extort money from a corporation, make sure it's fully cooked.
Pin it on a warm body, who's actually walking around, that's a pretty...
Mr. Reyes faces 4 years, 8 months. Those are the maximums.
To where we actually thought we had a suspect. We interviewed this person, we conducted various forensic...
All I know that she's a good person and that she's my sister and that I love her and I'll support her to the end.
Number 2, broken dreams. Most of us acknowledge that the beer commercial fantasy of beaches, babes, and booze is just that, a fantasy, and move on. Not Richard Overton. In 1991, he sued Anheuser-Busch for $10,000, citing false and misleading advertising that allegedly caused emotional distress, mental injury, and financial loss. Overton said the company's ads, which depicted beer's magical ability to facilitate scenic tropical settings and beautiful women and men engaged in endless and unrestricted merriment, turned out to be untrue.
About the beer.
Come on, I'm buying you a beer.
Okay.
What did they say?
Flight crews next door.
Or
okay.
You deserve to be here.
Congrats.
Or,
The case was dismissed. Overton didn't back down, though. In a 2007 interview with the Kalamazoo Gazette, he took umbrage at his popular image. Overton is a teetotaler with 3 children by his wife of 3 decades. The spark for the suit, he said, was seeing his young kids captivated by Spuds MacKenzie, the dog depicted in Bud Light commercials. I looked at them and I thought, this isn't right, Overton said. Here are my kids being drawn to part of the culture of alcohol because of this advertising. That's when I figured something needed to be done. Fair enough, but perhaps targeting the company's failure to turn boozy fantasies into reality was the wrong tactic. Number 1, Roy L. Pearson. Roy L. Pearson Jr. was just your average judge in Washington, D.C., until a neighborhood dry cleaner misplaced a pair of his trousers, arguing that he never received same-day service or satisfaction guaranteed as advertised by the mom-and-pop owners of custom cleaners.
Bob, if you want to come. It's been an amazing ordeal for them. Judges had to deal with this case is egregious, and so the cost to the taxpayers and the cost to pay the judge. So Mr. Pearson cost not only the Chungs but the taxpayers a lot of money that he was going to unhesitatingly appeal.
How much has been raised by
Pearson sought satisfaction the only way an overeducated lawyer knows how, by filing a $67 million lawsuit against store proprietors Sue and Jin Chung. In 2007, a judge ruled in favor of the Chungs, and Pearson walked away with nothing. But that didn't stop him from filing an appeal, which was also rejected.
Go to that extent, and then to see the system back it up. It's a lot of nonsense.
Means to a reasonable person, which is, if there's a problem, we'll try to fix it, and if we can't fix it, we'll give you the value.
We're exceedingly that we had his pants ready for him and that we hadn't in fact lost his pants. And with respect to the signage, the pants for a very short period of time, and would be willing to refund him the $10.50 he paid for them to be altered, like $67 million. This is a case that was originally about one pair of pants, and now it's about two. When the case started, their business was functioning very fluidly. And they've been faced with $67 million worth of claims from Roy Pearson. Now it's $54 million.
In the end, though, everybody lost. The Chungs had to shutter 2 of their 3 stores to finance their defense, and Pearson lost a job 4 months into the lawsuit after a review board found him lacking. The guy who literally tried to sue the pants off someone was fired from his job. Karma. That's all we have for you, folks. Join us next time.